Under the mayor's report, I do not have anything, so we're gonna move on to the city attorney report.
Sending a couple things around. One is what we filed in the last few days having to do with a hearing that was scheduled for earlier this morning. It was a hearing on whether a preliminary injunction would issue restraining our drawdown throughout the length of the lawsuit that's been filed against the city, and that particular period of time could go all the way through a trial scheduled hearing on the merits, which may be as late as next summer. So that particular matter, the city resisted. We submitted 19 exhibits, which was a bundle about as thick as your council packet for this week. But we also, in the last day, we received some late filings. We filed one more exhibit with the city administrator's help, which included some rebuttal information from Chad Dolan of DNR and also French Renneker as far as some things having to do with some measurement. After that occurred, we had a few shuffles. We had a change in the judge that was assigned to rotate in for today. We got the district's newest appointed judge, Amber Thompson, and she did look over things for a couple hours that we had submitted. Mr. Noyes also had an exhibit number 15 and some other attachments that were parts of earlier exhibits he'd submitted. So I think there was a relatively complete review, but the judge looked at this a little differently than Judge Showers when he ruled in the city's favor on the 26th of September. This judge looked at it as what else is there to decide if this preliminary injunction is subject to the same standard as applied to the temporary restraining order, which is basically, do you have likelihood to succeed on the part of the plaintiff? If they aren't going to prevail on their merits, that's a pretty good reason not to grant an injunction to stop things. Also, it's a question of, is there a risk of irreparable damage? That again was found in favor of the city. Is there a substantial immediate risk? That becomes less of an immediate question when you're looking at a preliminary injunction that might last for months. And ultimately, the judge said all of these issues have previously been considered, and she wasn't going to overturn what Judge Showers had previously ruled. So she basically said, there isn't anything more for the court to do with this today. Having reviewed it, she was just going to deny Mr. Noyes' request and leave the previous order in place. And essentially that means that there isn't any restraining order against our drawdown, and there isn't any longer term preliminary injunction against our drawdown. So we've been through an administrative law judge hearing that ruled in the city's favor. We've been through both a division director's determination on a one-day review where the division director was asked to overturn ALJ decision. And then we had a direct appeal to the state director of the Department of Natural Resources, who has authority under the code in a significant emergency to override the administrative law judge, and she declined to take jurisdiction and do that. Then we had the district court on the 26th of September ruled in the city's favor, and now we've had the last, what I would call the preliminary motions, ruled in the city's favor. None of these cast any doubt on the city's having proceeded legally. The exhibits that are in the list that was passed around to you include an exhibit from our city clerk explaining how she did everything by the book as far as the notices, the different hearings that were required to follow, the publication and so forth. The other parts of this as far as our engineer's affidavit, our city administrator's affidavit, our mayor's affidavit, all of those items have been considered by the court, and contrary to what's been on social media since early this summer, I'm happy to report to you that you haven't acted illegally. Happy to report to you that the court agrees that what you've been doing is what a city council is supposed to do. And that as far as our proceedings, there hasn't been anything raised that stops you from going forward. So at this point, the things that you want to resolve are in your hands as far as the court feeling you are the appropriate decision makers. You are also the persons who, if there's anything else over the next few months that you are inclined to reconsider, rescind, or change in some way. You just did another change order today as far as allowing the contractor that won the bid last winter and spring to do something different as far as the project going ahead with bridge removal. That being said, the bridge removal probably still going to meet with some objections, but the bridge removal, whether there is 6 feet of water out there or 2 feet of water out there, it's not ready to happen yet. So the city's watching that. I hear from our city administrator about every 2 days about we've dropped another 3 to 6 inches. At this rate, we're going to be all through the month of October probably before we have the drain down that we anticipated. But we may be quicker at the site of the bridge piers and the abutment, and I guess that's going to depend upon what the engineers, our city engineer and French Renneker's opinions are about the safe operating level of water in bridge area, and not having any obstacles anymore as far as legal proceedings or administrative proceedings to keep us from working at the bridge site. We should be able to remove the bridge this fall, assuming we don't have Halloween snowstorm or something like that. But I think you agree with me on that, don't you, Melanie? That we probably can get that done.
It's not gonna snow this year.
Not gonna snow at all this winter, apparently.
Correct, yeah, hold me to it.
Okay, well, hold you to that. Aside from that, we've got a couple things that, I've had a couple calls from my office about nuisance properties. We do need to deal with our absence of what's probably going to become a full-time job again as far as code inspection, enforcement, and I did, in respect to a couple of these locations, these are people that are self-policing themselves. One of the next property committee meetings, I expect we'll probably have 2 individuals in town that are prepared to give up property to the city Mr. Kevin Franklin did. And so we'll have some more infill property for those kinds of LMI possibilities. And we'll also, at the same time, we've had, I think, Hattery from Davenport, an inspection and appraisal visit. Have we got a report on that yet, Doug? We haven't, have we?
I have not.
Okay, well, that's something that we're waiting on, but I expect that it's gonna impact what we've got going on at the Penny Lane building at the corner of Court and Broadway. And those are things that are probably top of the list things with our code enforcement that we've been sort of sitting on our hands about. So apologize you for sitting on my hands. We've had other things we've been working on in the meantime. This thing with the group at the lake, I kind of hate to see some of the things that have been going on. We've had a couple of the election workers at the special election that asked for protection because of things that were said to them at the polling place. And there really isn't any place for that. I don't think it's the group that's talked to us openly here in public, but I think it's somebody that, my terminology would be a smartass. And that person, basically, one person attempted to convince the poll watchers that they were entitled to vote in 4 different districts in town because they had property in 4 different locations in
So I
town.
understand it was more than that, John? It was more than just one person, I
Oh,
think.
yeah, that was just one instance,
Right.
and there was some yelling and some cussing and some threatening. They had to have the auditor's office, Commissioner of Elections, go over to the polling place. That usually doesn't happen, but it's not the first time something like that's happened. We had a couple times back when I was county attorney in the 90s, when we had people show up and they wanted to vote on both parties' primaries at the same time. And they thought that was a really clever issue. Now, the state code's pretty specific. You have to be a registered voter in a particular party. But it got out of hand and we had to have the sheriff come over. We shouldn't have to have the sheriff come over for a runoff election. In a city matter, there's some heated discussions that take place here sometimes, but that shouldn't go outside of our open discussion. We're pretty, in spite of what you read on social media, we're pretty transparent. I don't think anybody that wanted to speak up here hasn't had a chance to say something in their time. So, I'll just say that that's not the way it's supposed to work. And we've got more elections coming up. I was at a Amish breakfast on Saturday down in Van Buren County. And some people from Mount Pleasant were there, and they said that people from our town had been over there talking to a church group, and they said that our election and the runoff was poorly handled, and that they were hearing all about it from people on the party side that lost. And I expect that probably some people that aren't ever going to be satisfied that they shouldn't have won. But that's what's nice about democratic processes, is that we do have checks and balances. We have voter canvassing. We have the honest election process in our auditor's office, and it's overseen by our state different departments as far as Secretary of State. So having said that, I'm at a point right now where I think we're done with these legal gyrations for a while with the lake. We have a hearing on the 18th of November to determine when there's going to be a trial date in district court on the merits. And that is probably not going to be until sometime next summer, based on the rules of civil procedure and the district court calendar. It's just even to a judge, there aren't very many trial periods opening up. On the other side of that, that's November 18th, and we'll more about how much time we get to do discovery, how much time we get to file motions. There may be quite a bit in our record already that would justify something called summary judgment, where the court would just be asked to find that most of the things that have been raised don't rise to the level of stopping our project or interfering with the lawful processes of the city government. That's my sense, that we could probably dispose of the case before you have a full trial, not any earlier next summer. On the administrative law judge side, there is a trial setting conference as far as discovery rules and so forth set for January 7th. That administrative process goes right along parallel with the district court process. Some of the same issues are in there, but I'm relatively confident that the administrative law judge that will be assigned to hearing this matter on the merits is going to be pretty well versed in the issues that have to do with the same things that DNR has opinions about. So at this point, I think DNR wholeheartedly agrees with the city's position that this should be projects that the council makes a decision about, and these are things that they understand why the city is going to be in charge of this, along with our retained engineering firm here in town, and that regardless of how well intentioned some other people are about the ideas they have and the engineering savings that they're going to bring to us and so forth, we have to act like a municipality. If we get sued, we have to look like a municipality. If we're going to get into a situation where we have to defend the way we've done things against claims of either defects or negligence, again, we have to act like a municipality, and we can't relinquish our position on that to people that want to pressure us to do that. If we want to reach some kind of an agreement, and we've got months to do that, and we've got other things to look at, nobody's telling you you can't look at every possibility. But so far, you have aired every possibility that I can see, and you've weighted against dollar costs, and you haven't seen a better or more cost efficient than what you are presently resolved on. Even when Mr. Hip was here and was showing us slideshow and things like that, he was not in a position where he could say he'd come up with a solution that was going to be any less expensive than what your low bid was. So at this point, I think you're about as far along as you can be on things either administratively or in district court legal terms going forward. So at this point, you still have your independent council member by council member decision-making abilities, but the legal system is basically showing you that you haven't been acting incorrectly, that you haven't acted in a manner that is outside of the scope of the things you're permitted to do. And so, you know, that's enough for me to say tonight.
So John, I have a question on that.
Yeah.
Is the only way that this stuff wouldn't go forward is if Mr. Ednoise withdraws all his?
He can dismiss anytime he wants to.
Okay.
We will have to, probably by the time we have our trial setting conference in late November, we'll have to decide if we want to ask the court to allow us to make any what was called permissive counterclaims. There are times, and they usually don't come into play until you file your formal answer on the longer, more big merits case. We have filed an answer in that now. We filed affirmative defenses to use as defense mechanisms in the trial if we have one next summer. But if you want to make counterclaims, things like intentional interference with our contract relationships, intentional slander of city title, abuse of process. Those are things that are out there. I'm not preaching that you should go to any of those. That's just gonna probably prolong the litigation. There aren't any other people named as a party in this litigation that we're involved with except Mr. Noyes. In spite of him claiming he's got unanimous support out there, he doesn't have anybody signed up to be a party. If he's your only party on the other side with an interest in this, I would expect at some point he'll see the light and maybe not want to push the envelope too much farther if it looks like there's no possible way that either the administrative law judge or the district court judge are gonna reverse themselves. So he's got the Iowa Supreme Court yet. I suppose he can try to take this upstairs, but the average appeal going to the Supreme Court right now, you pay about a $10,000 retainer to get somebody that specializes in that to take it forward for you, so I don't see that happening.
So John, I have an additional question, and that's pertaining to when we go into closed session. And, you know, it's generally these people here that are up in front.
Right.
You know, the city council, you, admin, clerk, engineer. What's your expectation of all of us here about discussing that outside of closed session?
Well, none of you have been sued individually. So there's a little litany of things I could tell you if you have this hanging over your head individually also, where you're probably going to need to understand that if that happens to you, you need to probably plan on being advised by an assigned counsel. ICAP has the capacity to have 7 different lawyers represent 7 different interests among the council here, plus your officers. And, you know, so if you have 10 different lawyers in the room with 10 different interests, that's possible. There's a case called Town of Suffolk, it's a U.S. Supreme Court case, that says everybody's interest is entitled to be protected. And if you vary in opinion from one to the other all the way around this table, you still get to have your individual opinion. But you may put yourself in a position where a lawyer has to tell you, no, you do not want to say that, or you don't want to be caught in that statement later on, because that may cause you to get a reservation of rights letter from
Is that your question?
Sure.
I don't know if are you answering, I don't know if that's a question. The question has to do, I think, you have a closed session. Is the session closed in the sense that the people who are participating in the session, are they allowed to, should they disseminate the information beyond the session? That's the question.
Yeah, the whole idea of a closed session is that it not be discussed in a way that would be disadvantageous to the city's position coming out of closed session. That still doesn't change the fact you're all entitled to your same opinions or different opinions. But you do have a kind of a break point where you do not want to go outside and put yourself in a position where you have excluded yourself possibly from the coverage that the city as a whole is entitled from ICAP. The city is also entitled under the code to indemnify you individually, assuming you.
Should you, when you're in a closed session, when you go out of a closed session, do you talk to other people about what happens in the closed session?
Is it confidential?
Yeah.
The idea is that you probably shouldn't, but the rest of the story is that some of this stuff it's on the front page of the newspaper already. It's not the kind of stuff you can say, none of you can talk about the bridge, and none of you can talk about the lake, because.
But strategy, we're talking about strategy, litigation strategy. That's the purpose of the closed session, isn't it?
Right, and so far, I think we've pretty much been inside ourselves here as far as the things we've done. You've given me authority each time we resisted something and went back to the documents to get a result from a hearing, and I think that pretty much worked the way that it was intended. Right now, there isn't a whole lot, if we were in closed session right now, we're talking about November 18th, and a trial setting hearing, there wouldn't be much about that that's secretive. It's in the rules of civil procedure, and us getting times and so forth, would probably not be a discussion about whether we're filing a motion for summary judgment, or whether we're gonna do some kind of discovery of certain kinds of people. There will probably come a time when that will be a possibility, and that's probably a time when you might have to have advice from somebody separate. It might be Ehlers, it might be 6 other law firms other than Ehlers, and as far as that goes, they may tell me to be quiet and that I've been turned into a witness of something. So I don't know that yet, but so far we've been going along with these preliminary motions and so forth.
I think what prompted the mayor's question, it has to do with a statement that was made earlier this evening by one of the participants before the council that suggested that there was information they had which probably was something shared in a structure where it was not supposed to be, not to be disclosed. A closed session, in other words.
Yeah, and we don't have to, I'm not
Be-
trying to dog it to death, I'm just trying to make sure that it's clear what's an expectation from all of us, in that. So unrelated to that, John, if I could just move on, because I think we've talked about that, and do we have any further, I know you've been busy on this particular thing, so is there anything new on the 2nd Street and Harrison fence issue?
No, we have had an inquiry from one of the neighbors down there about when we're gonna get back on track on that.
Yeah.
We do have a verbal understanding with the owner of that corner, that we can come back to him with a proposal as far as where his fence line should actually be, and probably cutting off a visibility problem with the corner of the 6-foot tall wood fence is a part of that solution no matter what.
Is that something that staff can go talk to the owner about and get that resolved? Would you be open to that?
I'll make it happen.
Well, let me just go back to one thing I want to say. It's quite, election interference or mistreating election workers is quite serious. My mother's a poll worker, even now at 90 years old, election worker. So it's a quite serious thing. And I do think that my understanding what happened is that there were people involved that are part, I don't know who, I'm not gonna say, I think there were people involved that were, when you say not part of this group, I think that's not true.
Well, I don't think they were the front end of the group. I don't think they were the people.
I don't know the details, but I would.
Speeches, I think they were people that were trying to test as far as they could get.
In any
I've
case,
been in that situation.
right,
before,
it's
somebody trying to
quite serious.
Get away with something that you can't have it both ways.
Right, it's quite serious. I just think we want to be careful about that going forward. I think there will be, unfortunately, going to have the additional protections at our polling places, but yeah, it's a quite serious matter.
I will say too that was brought to the attention of the supervisors and the sheriff's office.
Right.
Election interference at this point is investigated and prosecuted by the AG's office, so it wouldn't be a county or city issue. But I think that the awareness was brought to the issue to the various parties involved.
Great, thank you. Anything else, John?